In our previous class, we have seen that contracts are classified on the basis of enforceability into six types. In that, we have discussed about valid contract, void contract, and void agreement. Today, in this class, we are going to talk about the rest of the types of contracts on the basis of enforceability. So that is, fourth type is voidable contract. So what is voidable contract? It is mentioned or it is defined by section 2 subsection I of Indian Contract Act. What is voidable contract? So this is a point on which often 2 marks question is asked in section A, define voidable contract, or sometimes a case study will be asked on this point. Now what is voidable contract? The definition is like this. Voidable contract is an agreement which is enforceable by law at the option of one or more parties but not at the option of other or others is voidable contract. Now what does it mean by enforceable by law at the option of one or more parties and not at the option of other or others? That means whenever an agreement is created or agreement or contract has come into existence due to coercion, undue influence, fraud, and misrepresentation. So, a contract which was brought about by or which has come into existence as a result of due to coercion, undue influence, fraud, or misrepresentation, then that contract is voidable. Voidable at the option of whom? Voidable at the option of the party or person whose consent is caused by any of these factors. For example, when a contract is created between A and B, at that time A has a gun with him and A says that you sell your property which is worth 5 lakh rupees to me for 5,000 rupees. Because of the force which is induced, which is used by A, B agrees to the contract. B says that yes, I am ready to sell my property to you for 5,000 rupees. Now, why he has given a consent? He has given a consent because of coercion. His consent, B's consent is not free consent. Now, this contract will be voidable. At whose option this contract will be voidable? At the option of B, whose consent is not a free consent. B has given a consent because of the force which is induced by A. Therefore, B will have two options. If he wants to enforce that contract, if he wants to sell his property as per the terms of the contract just for 5,000 rupees to A, he can do so. He can enforce that contract. So that contract will be enforceable at the option of the one or more parties, but not at the option of the other or others. This contract will not be enforceable at the option of A, who is a party who has induced force on B, but it will be enforceable at B's option. So B will have two options. If he wants to enforce that contract, do whatever he has decided to do under a contract or sell his property for 5,000 rupees to A, he can do so. If he wants to get that contract cancelled, he can prove that he has given a consent or contract has come into existence because of coercion. His consent is not a free consent and get that contract cancelled. So this is voidable contract. Voidable contract is an agreement which is enforceable by law at the option of one or more parties. Means the party whose consent is not a free consent. And not at the option of other or others means the party who is responsible for inducing force or who has used undue influence, fraud or misrepresentation. In that case, contract will be voidable at the option of the person whose consent is caused by any of these four elements. Next type of contract is illegal contract or unlawful contract. Now, section 23 of Indian Contract Act says that any contract, the consideration or object of that agreement Consideration means something in return. So we have seen what does it mean by consideration. Consideration means both the parties should give something and get something in return in the contract. That is called as consideration. So any agreement in which consideration or object means the purpose or the reason for which the contract has come into existence. So any contract or any agreement, the consideration or object, purpose of that agreement is unlawful, which is not lawful, against the law, or if it is forbidden by law. Forbidden means prohibited by law, or law opposes that object or that consideration. Any agreement, the consideration, something in written, or the purpose of that agreement is unlawful if it is against the law, or law prohibits that, law opposes that, or that agreement or that consideration and object are of such a nature that if it is permitted, it would defeat the provisions of law. If that doing something or that purpose it is permitted, then it will be against the provisions of some law. It will be against the law which is in existence. Or that agreement means that consideration or that object of that agreement is with respect to involving injury to a person or property of another. Or court considers such an agreement or such consideration or such object as immoral or which is opposed to public policy, then such contract is called as illegal contract or unlawful contract. Now what is illegal or unlawful contract? Section 23 says that any agreement, the consideration or object of that agreement is unlawful, which is forbidden by law. Law prohibits it, law opposes that doing something, or is of such a nature that if it is permitted, it goes against the provisions of existing law, or that object or that consideration is regarding providing injury to a person or property of another, or court considers such doing something consideration as immoral or which is opposed to public policy, such an agreement is called as, such contract is called as illegal contract or unlawful contract. For example, whenever there is a contract to commit crime, contract which is of immoral nature or which is opposed to public policy, these are illegal in nature and such contracts will be called as unlawful, illegal contracts, and these contracts will not be enforceable by law. Contract regarding committing a crime or contract with respect to involving injury to person or property. Say for example, A says to B that I will pay you 10,000 rupees if you go and beat C. A tells B that I will pay you 10,000 rupees if you beat C. B goes and beats C. In such a case, if B again comes back to A and says that as per our contract I have beaten C, now give me 10,000 rupees. That contract is illegal, it is unlawful contract. Therefore, such contract is not enforceable by law. Again, if there is a contract between A, B and C, they have entered into contract or agreement, and agreement is regarding division of the gains. They have achieved something, they have got something or some money they have got, and they have agreed or they have entered into contract to divide that whatever they have amongst themselves. And what gains they have acquired it by committing fraud on someone. In this case, that agreement is void as it is the object, the purpose of that agreement is unlawful. So such agreements are called as illegal or unlawful contracts. These will not be enforceable by law. Next type of contract on the basis of enforceability is unenforceable contract. Now, which are unenforceable contracts? So those contracts will not be enforceable by law. Why? So these contracts are correct in all substance. They have all the essentials. Everything is correct. But there is some technical defect in those contracts. What is a technical defect? Say for example, we have seen that there are certain legal formalities which needs to be followed under different laws and acts. and those formalities, those technicalities have not been followed, and due to the technical defect, the contract becomes unenforceable. We have seen that legal formalities means some contract needs to be in writing and those needs to be registered. If those formalities are not followed, those contracts will be unenforceable contracts. That is absence in writing, barred by limitation. One or both the parties cannot sue upon it. So if an agreement which needs to be in writing, which needs to be registered, it is not registered and it is not in writing, then in that case, both the parties cannot sue upon it. Both or one of the parties cannot sue. They cannot file a case against non-performance of such a contract. So it is described as unenforceable contracts. So in simple terms, unenforceable contracts are those contracts which are correct in every substance, every respect, but some technical defects, there are some technical defects, some legal formalities are not followed, those contracts will be unenforceable contracts. For example, A and B enter into an oral agreement to pay time-barred debt. So this we have discussed in essentials of a valid contract. So it is required that whenever there is an agreement to pay time-barred debt, that agreement needs to be in writing. But here A and B have entered into an agreement to pay time-barred debt and it is oral agreement. So their formality, legal formality is not followed. It needs to be in writing by law. This agreement is unenforceable as law requires that an agreement to pay time-barred debt must be in writing. So that agreement will not be enforceable by law. So these are the 6 types of agreements, 6 types of contracts. The classification is made on the basis of enforceability. Thank you.